A neurosurgeon is found dead with gunshot wounds in the attic of his own home.
He was face down. He was only wearing socks. He was wrapped in a blood-soaked carpet.
But who had the motive to gun down this beloved doctor? Well, when police make an arrest, they discover a shocking tie between their suspect and the neurosurgeon. This is Inside the Crime, presented by Law&Crime. I'm Elizabeth Millner. Prosecutors say Dr. Devon Hoover was shot twice in the head, but it wasn't a random attack or some type of patient wanting revenge. This was a cold, calculated murder carried out by someone who was unknowingly close to the doctor.
At most, the evidence shows a relationship between the two men, but not an intentional or premeditated homicide.
Let's go back to 2023 for this case. On April 23rd of that year, police responded to the home of 53-year-old neurosurgeon Dr. Devon Hoover. The call for service reportedly came from Dr. Hoover's family, who just wanted a welfare check after Devon didn't show up for a visit to see his dying mother. Officers in Detroit, Michigan conducted the welfare check, but made a horrifying discovery.
Officers arrived and observed a white Range Rover blocking the driveway. They investigated further and noticed what appeared to be blood on the interior of the vehicle that was blocking the driveway. They secured the Range Rover, they tagged it as evidence, and towed it to the Detroit Police Department tow yard. The registered owner of that white Range Rover was discovered to be Dr. Devon Hoover of in Detroit. Detroit police officers went to that address that same evening and noted that the driveway gate leading to and from the rear of the house to be wide open. They were unable to contact anyone at that time at the residence, both knocking on the front and back doors of the house. The next day, on April the 23rd, 2023, Detroit Police Department received a 911 call from Dr. Hoover's family requesting a well-being check of his home, as they had been unable to reach him after he failed to come and see his dying mother in the state of Indiana. The Detroit Police Department went to and noticed that the driveway gate leading to the rear of the house was wide open. Further investigation revealed the presence of what appeared to be blood on the rear exterior side of the back entrance door of the home. A decision was made to force entry into the premises, and during that protective sweep of the home, Dr. Devon Hoover was found deceased in the third floor attic crawl space. He was face down. He was only wearing socks. He was wrapped in a blood-soaked carpet. He appeared to have been shot in the head.
When investigators searched his home, they noticed several of his personal belongings were gone. No cell phone, no wallet, no credit cards, and his designer watches were missing.
The investigation revealed that almost immediately following his murder, multiple fraudulent financial transactions were made from Dr. Hoover's various bank accounts. These transactions spawned for several days after that discovery.
So who was spending Dr. Hoover's money after he was murdered? Investigators needed to know who Dr. Hoover was last in touch with. Well, after diving into his phone records, detectives learned that there was someone Dr. Hoover was in contact with, a man named Desmond Burks.
That Dr. Hoover had approximately 4,000 communications with a number attributed to a Desmond Burks, who resided at in the city of Detroit. The text messages established that Desmond Burks and Dr. Hoover were in an intimate relationship with one another, and that on occasion Desmond Burks would charge Dr. Hoover for these sexual services. The investigation of this case was further complicated by the fact that many witnesses were extremely reluctant to come forward to share sensitive and personal information. The analysis also indicates that the day Dr. Hoover was murdered, Dr. Hoover's cell phone traveled from his West Boston Boulevard address to the area of Desmond Burks' address on Sussex. Dr. Hoover's phone appears to return to West Boston for a short period and then travels back to the area of Desmond Burks' residence on Sussex again before traveling to Fairlane Mall in Dearborn. Dr. Hoover's cell phone never returns back to his residence on West Boston. Numerous pieces of corroborating evidence place Dr. Hoover's cell phone in the same location as Desmond Burks. The evidence includes, but certainly is not limited to, what I'm about to say. Dr. Hoover's cell phone detail records, Google account search warrant returns, Desmond Burks' cellular phone detail records, Range Rover geolocation data, Project Greenlight video, 9901 Coyle Street video, and Golden Fantasy Jewelry Store video surveillance. Other physical evidence was discovered directly linking Dr. Hoover's property to Desmond Burks. On the date of the homicide, Desmond Burks is seen on surveillance camera parking Dr. Hoover's Range Rover near. He being Mr. Burks, is seen limping away carrying a backpack, and his fingerprint was discovered inside that Range Rover. At the time, Desmond Burks was known to walk with a limp due to previously being shot in the hip. Search warrants conducted at Dr. Burks' residence led to the recovery of one of Dr. Burks' Cartier watches that I mentioned earlier. Dr. Hoover purchased this watch in the year 2020 for approximately $6,000. An additional search warrant concluded at another recently discovered address of Desmond Burks back on April of this year, 2024, led to the discovery of another of Dr. Hoover's Cartier watches, a watch that Dr. Hoover purchased one day prior to his homicide. That watch was worth approximately $7,500.
Dr. Hoover was murdered in April of 2023. This press conference announcing an arrest in his murder happened in 2024. For Dr. Hoover's loved ones, they were finally relieved officials had a suspect in custody, who turns out also faced charges in another homicide.
Based on all of this evidence and much more further evidence, which we will outline in more detail in court, as a result of all of that, we are charging Desmond Burks today with one count of first-degree premeditated murder, count 2, felony murder, count 3, larceny of over $20,000, count 4, using a computer to commit a crime. The maximum imprisonment there is between 10 years or more, but less than 20 years. Count 5, possession of a firearm by a felon. Count 6, felony firearm, second offense, which goes to count 1. Count 7, felony firearm, second offense, which goes to count 2. And count 8, felony firearm, second offense, that goes to count 5. Please remember, as I said earlier, that this defendant is presumed innocent until proven guilty. And this is the same Desmond Burks that we charged on May 17, 2024, with another second-degree murder homicide. On May 17, 2024, we charged Desmond Burks, who was 33 at the time, in connection with a road rage incident that killed Mr. Salah, 87, of Dearborn. On October 17, 2024, at approximately 6:45 p.m., Detroit police officers were dispatched to an intersection of West Chicago and Greenfield Road for reports of an unconscious male laying in the street. Upon their arrival, officers located the victim, Mr. Salah, unresponsive, suffering from trauma to the head. Medics arrived on the scene and transported him to a local hospital for treatment. On May 11th, Mr. Salah unfortunately succumbed to his injuries and was pronounced deceased. It is alleged while approaching the intersection on West Chicago and Greenfield Road that Mr. Salah's vehicle bumped into the rear of Desmond Burks' vehicle, the car that he was driving. They both got out of their cars, and there was a verbal altercation. It is further alleged that we announced on the 17th of May that during this altercation, Mr. Burks punched Mr. Salah, leaving him lying in the street before fleeing the scene. And as I said before, he later died of those injuries. I should note that Mr. Burks is currently in the Wayne County Jail on a $1 million bond, no 10%. His lawyer in that case requested that he be evaluated for competency, and that request was made on May the 24th, 2024. The next court date for him in that case is September the 3rd, 2024, before Judge Kenneth King of the 36th District Court. That hearing is a competency review date hearing.
In a statement after this press conference, Dr. Hoover's family said, quote, "Today we feel relief for a step towards justice. He was an exceptional man, a doctor, brother, son, uncle, and friend who invested in our lives with unwavering kindness, and generosity. Although nothing will ever reverse our loss, we are grateful that someone will be held accountable for Devon's death. Since Desmond Burks' arrest, more details have been revealed in court. During a June 2025 hearing, one of Desmond's lovers testified about a bag Desmond allegedly gave the person. According to the Detroit Free Press, that lover couldn't be named in reports, and news outlets couldn't give away identifying descriptions, including gender, because of the judge's order. So we'll just have to call this witness the lover. According to the report, the lover testified that there were surgical glasses that had Dr. Hoover's name inscribed on them, as well as a 9mm handgun found in the bag Desmond had on him around the time of the murder. The lover testified they helped Desmond get rid of the items. First, it was the glasses the lover tore apart and threw in different trash cans. Then it was the bag the lover burned in a barbecue pit, along with the shirt and pair of jeans found inside. The lover said they also drove to a park to throw Desmond's gun into the river. According to police, Desmond allegedly stole more than $95,000 from Dr. Hoover, both in cash but also items like his Cartier watches. The day after Dr. Hoover's murder, the lover testified they gave Desmond a ride to Fairline Mall, and Desmond is even seen on video buying jewelry. Several of Desmond's other lovers also reportedly testified during one of his preliminary hearings. They testified they met Desmond on websites where people are looking for sexual encounters. Some lovers said Desmond didn't have a job. He made his money through sex work, essentially, or by selling pills. One witness testified Desmond would complain about not having money. Another witness testified about watching Dr. Hoover and a man with a cane having sex a day before the doctor's murder. During the June hearing, prosecutors read messages between Desmond and Dr. Hoover from April 22nd, a day before the doctor was found dead. Dr. Hoover reportedly asked Desmond whether he wanted to invite the individual back to his house to watch them have sex again, and Desmond reportedly responded, "I'm good on that unless you paying. I didn't like it. I just did it for you." The alleged killer appeared in court again this week, after his attorneys filed a motion to quash, claiming the state doesn't have enough evidence.
Judge, I just want to start by saying that the evidence at the preliminary examination does not establish that Mr. Burks killed Dr. Hoover intentionally, accidentally, or otherwise. The people's theory of this case is circumstantial at every turn. There are witnesses, several witnesses in this case, that the people are relying on to construct a chain of inferences that's simply too attenuated to support probable cause in this case. Several of the witnesses were granted immunity in this case. They admitted on the stand to destroying evidence in this case, burning clothes, disposing of the alleged weapon used, but received immunity for their cooperation, Judge. That directly impacts their credibility in this case. The credibility issues taken together with the other issues in this case render the bind over improper. I'm going to turn to the specific charges now. First-degree murder, as this court knows, requires premeditation and deliberation, and the prosecution failed to establish any of this during the preliminary examination. There's no evidence whatsoever in this case of a plan, motive, or deliberation. There's no communication suggesting intent, no statements, no preparations, and no actions before or after that support a deliberate killing in this case. The people attempted to infer premeditation here from the fact that Mr. Burks was allegedly seen with a handgun about a month before Dr. Hoover was killed, but mere possession of a firearm weeks earlier does not show intent to kill Dr. Hoover, nor does it show premeditation. Mr. Burks may have had contact with Dr. Hoover and was later linked to property allegedly belonging to him, and the prosecutor wants us to believe that Mr. Burks must have killed him based on that. That inference requires stacking speculation upon speculation in this case. At most, the evidence shows a relationship between the two men, but not an intentional or premeditated homicide. Without the evidence of motive, planning, or deliberate action, the charge of first-degree premeditated murder cannot stand. I secondly want to move to the felony murder count. The connection between the homicide and the other felony cannot be established through the testimony. The evidence shows from the preliminary examination that the Cash App transfers, the jewelry purchases, all occurred after Dr. Hoover's death. The felony murder doctrine only applies when the intent to steal exists at the time of the homicide. If the intent to steal was formed after, that's not felony murder, Judge. And this is precisely the case here. The prosecution's evidence suggests at most that after Dr. Hoover was deceased, someone used his accounts and property. There's no testimony, no record evidence, no forensic link showing Mr. Burks killed Dr. Hoover in order to commit a larceny. Even assuming that Mr. Burks later participated in the financial fraud, that conduct is legally distinct as occurring after the homicide. The required nexus for felony murder simply is not there. I would like to finish by saying, since these counts can't stand against Mr. Burks, neither can either of the felony firearm counts that he's charged with. I believe in this case, the magistrate who heard the preliminary examination evidence, that was mostly speculation and testimony from witnesses who were under immunity. And all of the exhibits, I believe the magistrate abused his discretion in binding Mr. Burks over on these charges. And I would ask the court to quash the information at this time.
So that was the defense's argument, and as you heard from the state, prosecutors stand by their evidence. But let's hear what the judge has to say. Will he toss the charges?
The court finds that a felony has been committed and probable cause that the defendant committed it. That's People v. Stone 463 Mich 558 2001. Probable cause exists where the court finds a reasonable ground of suspicion supported by circumstances sufficiently strong in themselves to warrant a cautious person to believe that the defendant is guilty of the charged offense. That's People v. Orzam 224 Mich. App 551 1997, as well as People v. Regal 223 Mich. App 34 1997. Guilt beyond a reasonable doubt need not be proven at the preliminary examination. To justify a bind over, there must be some evidence from which each element of the charged offense may be inferred. If credible evidence conflicts and raises a reasonable doubt as to the defendant's guilt, then the issue of guilt still becomes a question of fact left to the trier of fact. That's People v. King 412 Mich. 145 1981. In making the determination as to whether the defendant should be bound over to circuit court, the examining magistrate must determine the weight and the competency of the evidence. Now, pursuant to People v. Henderson 282 Mich. App 307 2009, a district court's ruling that alleged conduct falls within the scope of a criminal law is a question of law that is reviewed de novo. But a decision to bind a defendant over on the factual sufficiency of the evidence is reviewed for an abuse of discretion. And when a circuit court reviews a bind-over decision pursuant to the Henderson case from a district court, it must consider the entire record of the preliminary examination and not substitute its judgment for that of the district court. The prosecution in this case, and in its motion, lays out the allegations and their theory of this case. And these are at this time only allegations. The investigation, based on the preliminary examination transcript this court read, began as a result of a complaint that a white Land Rover was blocking a driveway at 9901 Coyle Street in the city of Detroit. There was alleged blood in the interior of the vehicle. The vehicle belonged to Dr. Devon Hoover. Shortly thereafter, there was a wellness check at the home of Dr. Devon Hoover at 150 West Boston Boulevard in the city of Detroit. The driveway gate was open. There was blood near the back exterior entrance of the home. After a search of the home, Dr. Hoover was found in the third-floor crawl space in the attic. An autopsy was conducted by Dr. Lee Lavity, in which she opined that the cause of death was 2 gunshot wounds to the head, and the manner of death was homicide. Now, at the preliminary examination, the prosecution presented evidence linking Mr. Burks to the homicide. Immediately after the homicide, evidence showed that the defendant siphoned off over $20,000 from Dr. Hoover's accounts and transferred that money to Mr. Burks' associates in Cash App accounts. Mr. Burks then told his associates to transfer all or some of the money back to him in his Cash App account. The allegations are that he coordinated with an associate to use Dr. Hoover's credit card. Now, evidence based on phone records and data and cell phone analysis was that he being Mr. Burks, was going to meet up with Dr. Hoover on April 22nd of 2023, had a personal relationship with him. Circumstantial evidence allegedly shows he was with Dr. Cooper on or about the time of the homicide, and the defendant retained Dr. Hoover's phone. After the homicide had occurred, Mr. Burks was in possession of a large amount of money and indicated to one associate that he had enough money to buy a house. The evidence showed before this incident that the defendant had a very low income and lived in part off the money of other people. Now, the evidence admitted in the preliminary examination also shows that the defendant drove Dr. Hoover's Land Rover with blood inside the vehicle to 9901 Coyle Street on the day of the homicide. His actions after the homicide, it could be argued, and I know the prosecution is arguing this, can show a consciousness of guilt and a potential cover-up of the homicide, including getting rid of a handgun. He sought to himself and to other associates delete information on cell phones and to change phone numbers. Mr. Burks allegedly was in possession of Dr. Hoover's personal items and allegedly burned the clothes that he was wearing on the day of the homicide. Information also showed that the defendant immediately went to buy jewelry after the homicide at Fairlane Mall. There was a lot of other evidence introduced at the preliminary examination, including evidence that the prosecution uses to link Mr. Burks to Dr. Hoover's death. Now, with regards to the first count of homicide murder in the first degree premeditated, to constitute first degree premeditated murder, it must be established that a defendant's intentional killing of another was deliberate and with premeditation. That's People v. Youngblood 165 Mich. App 381, 1988. While the length of time needed to measure and evaluate a choice before it is made is incapable of precise determination, there must be some interval in which a second look can be contemplated. That's People v. Furman 158 Mich. App 302, 1987. Premeditation and deliberation may be inferred from the facts and circumstances established on the record. People v. Gonzalez 178 Mich. App 526, 1989. Though not exclusive, the factors which may be considered to establish premeditation include the previous relationship between the defendant and the victim. And here there was a previous personal relationship between the two. A second factor is the defendant's actions before and after the crime. The court can take, certainly an emotion like this, the defendant's actions after the crime to show a premeditation to kill. And based on what the courts indicated and what was alleged, that can be enough based on the actions of the defendant immediately after the homicide to show potentially premeditation. A third aspect, a third factor, is the circumstance of the killing itself, including the weapons used and the location of the wounds inflicted. These are 2 gunshot wounds to the head. There is enough evidence to go forward on count 1. With regards to counts 2 and 3, larceny, $20,000 or more is count 3, and homicide, felony murder is count 2. The allegations are that, for instance, there was a Range Rover SUV, keys that were taken, a cell phone that was taken, cash, credit cards, financial devices by Mr. Burks from Dr. Hoover. And the evidence does indicate it was $20,000 or more, and that would be a predicate of the underlying felony for count 2. So there is enough evidence to go to trial on that count as well. With regards to the computer used to commit a crime, there is an allegation that with regards to the Cash App accounts that has already been explained and discussed by the court, that it was used to commit a crime for that purpose. There's enough evidence there. There was a stipulation for count 5, weapons found in possession. And the other felony firearm counts that are associated with those counts, there has been enough evidence to go to trial on all of those charges. Yes, there is a circumstantial case. The court does really appreciate the arguments made by Ms. Krause. It is a circumstantial case. As both parties are aware, circumstantial evidence can be used at a trial. And I also want to indicate this is a preliminary examination. This is a motion to quash. These are allegations at this time, and but the motion to quash, based on the case law, based on the facts of this case that were presented to the court, this court cannot say that there was a abuse of discretion by the district court magistrate in binding the defendant over on these charges.
As you just heard from the judge, the case will move forward, and pending any possible plea negotiations, the case is set to go in front of a jury for trial. Desmond Burks' next court date is scheduled for Friday, December 5th, and the judge said that date would be the cutoff date for any type of plea negotiations. Thanks for tuning into this episode of Inside the Crime. I'm Elizabeth Millner.